If people could find their seats, we'll get started in about a minute. Welcome to the panel on existing legal structures for resettlement and migration. We have a very distinguished panel today. There's been one change from the printed program. We've added to the speaker list for this morning Siobhan McInerney Langford of the World Bank, who was originally scheduled to speak tomorrow, but it fits much better for her to speak today. So the first of our speakers is Michelle Klein-Solomon, who is with the International Organization for Migration.
Fine. Thank you very much, Michael, and welcome. Thank you very much to you and Gregory and the others for inviting the International Organization for Migration to participate. It really is an honor and a pleasure to be here today. For those of you who don't know us, we're the principal intergovernmental organization on migration worldwide, made up of 132 member states headquartered in Geneva, with some 400 offices worldwide, addressing the full range of migration issues. I'm happy to talk about that more. I'm going to do something I never like to do at the beginning of a presentation, and that's to offer an apology. And it's a sincere one. I had hoped to be with you here yesterday to hear all of the presentations, which interest me enormously. Unfortunately, I came down with food poisoning and could not. That also explains why I have no PowerPoint, because yesterday was my day to listen to you and then transform my speaking notes into a PowerPoint to offer to you today. So I offer that because I apologize if some of what I have to say today was covered yesterday. I hope it will be seen as complementary to that, and I will be speaking from notes rather than from a PowerPoint, but I'll be happy to follow up in writing. Let me say a few things at the outset based on what I heard this morning that are not in my notes, and that's a bit of context setting. As Michael said, I'll be talking a bit about the refugee and migration law related frameworks that are relevant here, as well as human rights frameworks, which Siobhan will go into in more detail. But let me set a bit of the context in the refugee migration realm, because I think the scale question and the overall context is important before we start talking about what potential legal mechanisms to look at. And this relates to something that one of the representatives of the Republic of the Marshall Islands asked in the last session. First of all, the UN estimates that there are 214 international migrants today, and that there are 214 million, not just 214, definitely not just 214, 214 million international migrants in the world today. And they estimate as well that there are another 740 million internally displaced persons. Obviously substantially higher. So about in total 1 billion people who have left their habitual places of residence to find residence someplace else. The current estimate of the number of people who are likely to be displaced as a result of environmental and climate change related factors is some 250 million by the year 2050. I have to say that that is a guesstimate. I mean, you will have also heard some estimates from 50 million all the way up to 1 or 2 billion people displaced in that same time frame. These really are guesstimates. The number that we use, it's based on something that was done by Ollie Brown, is 250 million people, but there's very little ability to scientifically relate that to numbers specifically. I know a lot of you talked this morning about the fact that it's not just something in the future, it's happening now in many places, but to actually pinpoint, and this is one of my second points in the context, to actually pinpoint climate change per se as the reason that someone moves is very difficult. In most instances, climate change is exacerbating existing environmental degradation. It may become the tipping point, it may be the extra factor that leads to someone making a decision to move, but it is very difficult factually and certainly legally to isolate climate change as the specific precipitating factor of movement. And that has very important implications for the legal discussion that we're about to have. It's also important to remember that the overwhelming majority of people who are displaced as a result of environmental factors and exacerbated by climate change are likely to be displaced within their own countries. Overwhelmingly so, and I can point you to a study that IOM did 2 years ago called Assessing the Evidence, bringing together many of the climate science people together with migration specialists to really look at not only the case of Bangladesh, which obviously was studied in some great detail, but many others, that the overwhelming majority of displacement related to climate change is likely to be internal within countries. Only a tiny portion of the people who are displaced are likely to cross international borders, and those borders are likely to be from one country adjoining another country, and they're likely to be south-south movements from countries in the south in the developing world or in the less emitting world, as I've heard today, the less emitting world, to other countries in the less emitting world. And it's also not likely to be the most vulnerable who move. And I think these are important things to bear in mind, because if we're looking to create solutions, and in particular legal solutions, you have to really take in mind who it is that we're talking about trying to address, and therefore what are the circumstances, and therefore what kind of need needs to be addressed. I also say this because it's important to realize that even those existing 214 million international migrants in the world today represent only 3% of the global population. That's a tiny number of people. I stress, and even if the worst-case scenarios were realized with respect to displacement, and another 250 million people were displaced as a result of environmental factors exacerbated by climate change over the next 25 to 30 years, we're still talking about a tiny portion of the world's population. I say this not because I don't think it's important, not because I don't think it's compelling and that the human suffering issues are compelling, but I say this because I think it's tremendously important not to fuel the overwhelming fears of the developed world being awash with people who are coming into their countries and taking jobs and burdening social security mechanisms. As was referred to by one of the speakers from one of the questioners from Brazil at the last panel, that there is already too much hysteria about migration issues, too much racism and discrimination, and we should be well advised to avoid fueling that further here in this case, because it is certainly not going to result in better protections for anyone. So I think I say this as a way not to, again, to minimize the significance of the very real needs, but to keep a perspective about this, that we're really not talking about enormous numbers relative to global populations, and we're not talking about hordes of people flooding into the Western industrialized developed countries. And so we don't need further repressive legislation and xenophobic debates as a result of this discussion. Let me say one thing, again, before I go into the legal aspects about what IOM's aspirations are in this area, and we can certainly come back to that in more detail in the questions. The first, and this very much echoes what the representative of the Marshall Islands said this morning, that the first is to prevent human suffering, and therefore to limit as much as possible the consequences of environmental degradation exacerbated by climate change, and to really reduce the incidence of forced migration as much as we possibly can. And there are things that can be done. There are things that are being done in many different parts of the world. They're largely very local. But that's not surprising because these issues happen in a very local way, and the remedies in many cases need to be local. For example, creating new livelihood opportunities, moving people voluntarily just a few miles away from where they had been before in order to be able to create livelihoods. As was said by so many people before, most people don't want to leave their homes. They don't want to travel to a completely different environment and have to stake out and face the challenges of creating a whole new life. Our second objective is to recognize that some forced migration will occur and actually is occurring, and therefore we need to mobilize to ensure protection and assistance for those who are displaced, and most importantly, to find durable solutions for them. And my third point, in terms of what we are seeking to accomplish in this area, is to recognize that migration, while it is generally a strategy of last resort, can sometimes be an adaptive strategy and can be something that is used in an anticipatory way by small groups of people to, when the areas in which they're inhabiting stop losing their productive capacity to be able to sustain livelihoods, to look at selective labor migration schemes that can help build diverse livelihood strategies, even send back remittances that can be channeled into building the resilience of communities and creating a place to come home to and future strategies. Okay, that's enough for the introductory comments. Let me move into the law aspects. And my part of the law aspects will focus very much on the existing frameworks relating to refugee and migration law, some on human rights law, but basically law that deals with the movement of people and to what extent it is relevant specifically in the instance of persons displaced as a result of environmental degradation and exacerbated climate change, and then even more specifically to the particular topic we're looking at today with the sinking islands. In this, climate change is expected to affect the movement of people in 4 ways, with all the caveats that I offered before. First, leading to greater frequency and potentially greater intensity of weather-related natural hazards, both sudden ones, extreme events, and slower onset ones. This means that there's likely to be more humanitarian emergencies and increased population movements. Second scenario is the adverse consequences of increased warming, climate variability, and other effects for livelihoods, public health, food security, and water availability, exacerbating existing vulnerabilities. Third would be the rising sea levels, and particularly in the coastal areas that we've talked about, and making low-lying lands uninhabitable. And fourth would be competition for shrinking natural resources, exacerbating existing tensions and potentially leading to conflict, which could also lead to displacement. And looking at each of these scenarios requires breaking down the different kinds of solutions and what's needed. Let me start first with cross-border migration, environmental migration, and with the caveat again that there's no definition, internationally legal recognized definition of an environmental migrant. I thought what Robin Bronin said in the last session was extremely important, that the refugee framework is not directly relevant, but there are some analogies that can be drawn. And look at international legal protection and assistance in this context. For cross-border movements, it is often said that that's where the greatest gap in terms of international law would exist, because persons moving across an international border as a result of environmental factors are not refugees by the normal definition in the 1951 Convention and the 1967 Protocol. That is particularly for several reasons, and please stop me if you've gone into this already. Have you gone into this, the particular reasons? I know Robin referred to it, but nobody's raising your hand, so let me give you a very quick why, regrettably, the existing international legal framework for refugees, it does not apply. Refugee protection, as Robin referred to, is basically in place of state. It's when the state has failed its citizens and, in fact, is turning on its citizens in a form of persecution. And international law recognizes a very small, narrowly defined group of persons for which international protection will be provided because of the failure of state protection. And here, the key reasons that framework is not relevant to persons moving as a result of environmental factors are these. First, the definition applies, the Refugee Convention applies in the first instance only to people who have already crossed an international border. It is not a basis of admission into any other state. It is, in fact, an obligation not to send somebody back to a place of persecution. It is not a grounds for admission. And what we're talking about here is looking at how we could facilitate admission to other states to provide protection. Second, it's very hard to characterize climate change as persecution. Again, a refugee is someone who has suffered a well-founded fear, who has a well-founded fear of persecution on account of certain grounds. Persecution is defined in international law, and it involves a series of very of extreme human rights violations that are sufficiently serious owing to their nature or repetition to constitute persecution. And it remains, even in the refugee context, very much a question of degree and proportion, and it is assessed in an individual case for an individual person's situation according to the nature of the right at risk, the nature and severity of the restriction, and the likelihood of the restriction eventuating in the individual case. General claims based on climate change do not meet this persecution threshold. Thirdly, even if it were possible to establish that the impacts of climate change constituted persecution, the Refugee Convention poses an additional hurdle, namely that persecution under the Refugee Convention has to be on account of an individual's race, religion, nationality, political opinion, membership of a particular social group. The impacts of climate change are largely indiscriminate, affecting large groups of people, and don't segregate by political opinion or gender or ethnicity. Now, it is possible, it is hypothetically and practically possible for a very limited group of people to be protected under the Refugee Convention as a result of climate change. But that would have to take place if government policies targeted particular groups reliant, for example, on agriculture for survival, or use starvation as a tool. So those are the reasons, in very short, that refugee law, as it currently is formulated, doesn't apply to the situation of persons moving across an international border. But and why many have said that there's a need for a new instrument in this area. The fact that the Refugee Convention doesn't apply doesn't mean that international law doesn't apply, and it's important to bring out, and Siobhan will do that in more detail in a moment, that international human rights law applies, as does consular law, including the responsibility of states to protect their citizens overseas. And that there is under a whole host, I'm going to skip over the human rights law because I know Siobhan, I know her presentation very well, and it's excellent, and I'll let her delve into that in greater detail. But human rights law provides an existing and very real foundation for addressing the needs of persons and the protection rights of persons who may be displaced across an international border. The issue is one that was referred to in the last panel, which is how de facto to ensure that that's implemented. It exists on paper, it exists, and there are mechanisms for enforcement, but unfortunately, as with many aspects of international human rights law, enforcement is the biggest issue rather than the scope of applicability. Let me jump very quickly to the situation of people moving internally. And there, as was already said, the major, if someone moving within their own country obviously is principally under the jurisdiction and the responsibility of their own state. And here, we've heard from so many of the representatives in the room that there is not a lack of willingness on the part of the state to protect its people. It's not a lack of a desire to protect own people. There's an inability in some situations to protect and assist your own people. And so the real issue is what principles can be evolved to support state protection in this context. And there was already reference by Robin to the guiding principles on internally displaced persons persons, which already specifically recognize persons displaced as a result of environmental factors as falling within their purview. These are guiding principles. They are non-binding, but they are put forward as a guide for state behavior as well as for the behavior of international actors, and really look from a protection and assistance perspective at what can be done for persons who are displaced as a result of environmental factors as well as of conflict. Let me turn in my last few minutes to the specific problems relating to the issue of disappearing states. And you had a panel yesterday on statelessness and the reduction of statelessness. And I think the conventions that exist in this area are ones that ought to be explored further as to their potential applicability here. But going forward, let me raise some questions for consideration in looking at the existing, whether the question that you'll be addressing in the next panel about whether a new instrument is needed, and if so, what kind of instrument to address what kind of situation. And let me raise some questions, many of which have been studied and written about in large detail by Jane McAdam. I don't know her yet, and I'm looking forward to meeting her. I know she's in this room somewhere, but her writing is really quite extraordinary on this subject. I think she raises some very important issues about the temporal aspect. When we're talking about displacement, in most situations, the extreme event is not going to be the situation that we need to address most systematically. It's going to be the slow evolving situation, and most of the international frameworks aren't addressed to that because it raises the element of choice. When does a particular person move? Does that affect whether or not that movement was voluntary, a judgment about that? Does it, we need to be able to contemplate that people will move over different points in time but still be affected by the same result. Second is clearly what I raised before, the difficulty of clearly separating climate change as the precipitating factor. And that's related to the second, which is distinguishing, looking at a collective versus an individual response. It would be very hard to argue in the context of climate change-induced displacement that an individual status determination, which is what we have under Refugee Convention framework, would be the most effective means of going about protecting and assisting people. We've got to think about a different way of responding here. And finally, the question of who would be responsible. There's the notion that was floating around the room this morning, I think compellingly, about compensation and trying to get to sort of the root causes and trying to find someone accountable. I think that's going to be extraordinary, particularly from a perspective of compensation, will be very difficult to identify who, at least on an individual basis, perhaps on a collective basis, who was legally responsible for causing the situation that led to a particular result and therefore is legally liable for the remedy that should be offered. My final point is that what we're seeing now in some, and some of you raised this in the questions for the last session, is maybe rather than a collective framework evolving, regional or situation-specific mechanisms to look at addressing displacement in this sort. And I'm aware of some that are evolving quite naturally already. Relationships that are being forged on a bilateral basis, now being talked about potentially on a regional basis where there are historical ties between countries and an interest in ensuring some kind of a collective response. To my mind, those kinds of measures are likely to be more constructive at this moment than something that's more global. The very last point is, of course, the Cancun and Copenhagen frameworks. And they did finally, in the end, basically create a placeholder on displacement and relocation. It is only that. It's only a placeholder. It creates no obligations on any states, no rights for any individuals. It does not create any binding legal framework, but it does create a space on which to develop further notions of potential collective responsibility in this area. Thank you very much.
find yours.
It's the next one over.
So it's now my pleasure to introduce Siobhan McInerney Langford from the World Bank.
Thank you very much. It's a real pleasure to be here for lots of reasons. We are just starting to work with Republic of Marshall Islands on the second phase of this research, and are really excited about what that will yield. I'd just like to talk a little bit about why we're looking at this and the origins of the project. It's a small research project which I lead on human rights and climate change, which tried to focus on the legal aspects and consolidating legal thinking, connecting these two fields of law. So the first phase of the project finished earlier this year, and we published a small study which aimed, as I said, to bring together the thinking on these two disparate areas of law, look at the points of connection and intersection and the areas of tension and disconnect. And we didn't aim to put forward any strong policy options, but rather to set out in a clear way the thinking to date and potential avenues for going forward. So I want to also thank Michael and everyone here who brought this event together. As I say, we're really happy to be here, but also to support it because of its direct relevance to what we've done and what we hope to do going forward with Marshall Islands. Okay. I was struck over the past day and a half at the prominence of human rights in the discussions. I wasn't always hearing rights discourse or an explicit reference to particular substantive rights, either at the international or even the national level. But it struck me that, as with other discussions around the plight of small island states, the prominence of human rights is undeniable, as is also the theme that is recurring, I think, of climate justice. And I'll get back to that a little later about how it is that we in our research felt that human rights and human rights law in particular informed this idea of climate justice. We also put together and came up with justifications for action based on human rights law. So what is it that's extant in existing human rights law that prompts us to action? And then, as I said, points of connection between climate change frameworks at the public international level and human rights on the other, and the question of value added. This is, as everybody has acknowledged in presentations and in discussion, an exceedingly complex area, politically fraught also. So what is it that bringing a human rights lens would actually contribute? So our initiative in the bank is obviously not one in isolation, and nor was it the first. I think a landmark initiative was, of course, the Inuit petition before the Inter-American Commission on Human Rights. We can get into this in the discussion, but many of you will know that the Inuit communities brought a claim against the United States for violation of human rights based on CO2 emissions. The Commission, of course, did not hear the petition on the basis that it didn't have sufficient information at the time to resolve the claim. Next, the Malay Declaration, led by Maldives, which galvanized the support of small island states around the theme of human rights and climate change, framing the climate change issue as one of human rights, but also focusing on the human impacts, the social and human impacts, and requesting a debate at the United Nations. Also in Bali, a side event organized by CIEL, which many of you will be familiar with, also laid down a baseline in terms of thinking and articulating the connection between human rights and climate change. And then a number of initiatives before the UN Human Rights Council, resolutions passed in 2008 and 2009, which called for a study, a systematic study, to be done within existing resources, I might add, but then also calling for a debate which took place in March 2009. And then more recently, earlier this year, a resolution on human rights and the environment, so broadening the frame of reference somewhat. What research then has been done? As I said, we're not alone in this field. The International Council on Human Rights Policy, the think tank in Geneva, published a very comprehensive, short but comprehensive piece in 2008, which it called a rough guide. I think it does much more than that, but it set out a framework for considering the two issues side by side, and as I said, the points of connection and tension. It does so not exclusively focused on international law, which our piece does, and it followed this with work on climate change and technology transfer this year. Based on the resolutions of the Human Rights Council, the OHCHR did publish a study in 2009 on the link between climate change and human rights. It analyzed right by right the impacts that climate change was already having on human rights and the enjoyment of human rights, as well as projected impacts, but it did not find, and it did not make any clear statement that climate change would in fact result in a violation of human rights, so that there was a difference there, and a slightly more limited conclusions. Many of you will know Mary Robinson, former President of Ireland and High Commissioner for Human Rights. She has begun a new initiative based in Dublin, which is focused on climate justice. And then our own work in the World Bank, which began in 2008, and we will conclude this year with the country-based study in Marshall Islands. So we were challenged a lot at the beginning of this project, and I'll probably be challenged in the Q&A too, but how is it that we would conceptualize the links between climate change and human rights? Even the brightest of lawyers that we debated the question with were asking us, well, why these two issues seem to us separate. So here's an attempt to try to conceptualize the connections. First, that climate change would impact the enjoyment of human rights. We have heard, I think, evidence over the past day and a half of exactly how that will happen across the panoply of rights, both civil and political rights, as well as economic and social rights, and the right to life itself. Second, that human rights obligations are relevant to responses to climate change and to promoting climate resilience. I think that's a more policy-oriented, perhaps more positive and forward-looking way in which to view the connections. Countries that are, at this time, both at the national and international level, designing policies related to climate change, particularly in adaptation, are also parties to human rights treaties at, again, the international level in universal United Nations instruments, but also at the regional level. Then a note of caution: not every action to combat climate change and to address its impacts is human rights neutral. I think the example of biofuels and the impact on the right to food was one fairly prominent example that was drawn out in 2008. Also, the rights of indigenous peoples in the context of initiatives like RED. But why is it a human rights issue? This is the question I get most often. The social, coming from the context of the World Bank, where we're not used to using rights discourse as a way of framing issues or solving problems, there was widespread acknowledgement of the social and human impacts, and no great difficulty with conceptualizing that, or indeed doing a vast array of research and analytic work on the social dimensions of climate change, as it was called. But really, why was it a human rights issue? And this goes back to the point which we felt we could contribute to clarifying from the perspective of international law, is that these impacts will affect rights that are protected at international law and in domestic legal frameworks. Then not a strictly legal point, but that the impacts are borne disproportionately then by those that are most vulnerable. I think that's connected with a core tenet of a rights-based approach, which is a focus on the most vulnerable and marginalized. And so with that lens, human rights law demands a focus on that feature, the fact that the impacts are borne disproportionately by those that are already vulnerable and likely to increase their vulnerability. And then what we sometimes called an equity issue, a fairness issue, which is that the impacts would be borne also by those least responsible for the problem. And you could analyze that both in terms of impacts between states, so what we call the macro level. The economists in the room will jump on me, but macro levels, so between countries. But also you could identify those last 2 points within countries, so talking about vulnerable groups and communities within countries. So the value added of human rights. So what is it that's specific to the human rights framework that it contributes to this debate? This may be just because we looked at it from a legal perspective, but the idea of accountability. I'm not suggesting, and I will come to this in my concluding remarks, that human rights has all the answers, or that you'll find tidy legal remedies to the problems that are presented by climate change, but rather that in terms of a frame of reference, the focus on accountability because of rights and duties, and at least the identification of duty bearers in international human rights law was already one element of value added. You could then go deeper in terms of the content, the nature of human rights obligations, and look at substantive standards. So the idea that you would, through the treaties, identify substantive baselines, particularly economic and social rights, but to look at those and how they've been elaborated by expert committees, by the Human Rights Council itself, but also at the regional level where the specificity of context is perhaps best understood. Then also procedural standards. So you could divide it, as I say, between substantive standards and procedural standards. And here the emphasis is how human rights can contribute perspectives on participation, on consultation, on the right to information. And there the jurisprudence is a little bit stronger. And there is also, of course, the Aarhus Convention. Then a focus on vulnerable groups, which I mentioned earlier, and prioritizing human and social dimensions of climate change rather than viewing it in more technical terms, perhaps adding this human face, which again I think has been so effectively done in the past day or two. Then the justice and fairness arguments and the value of human rights in terms of mobilizing political will and advocacy. But as I said, the part of what we're tackling is that the two issues, climate change and human rights, are viewed to occupy separate spheres, and that this is played out also in terms of international law. So in the study, we tried to look at the bases for convergence. So these were divided into structural considerations. So the idea that in international law there is a presumption against conflict based on the Vienna Convention, or the avoidance of fragmentation in international law, which I think Marty Koskaniemi has written about, and the ILC proposal for systematic integration in terms of how obligations in one sphere might be applied or interpreted in another. Then the simple fact that I mentioned earlier, which is that states may be party to both, for instance, UNFCCC and the International Covenant on Economic and Social Rights, and that very fact raises a question about how action in the sphere of climate change should take into account obligations under human rights treaties. And then some principles where we went through and tried to identify analogues. It's not a perfect analysis, but these are examples of areas of principle where you could identify a level of convergence. One is accountability, which crosses the entirety of the International Human Rights Treaty framework. And in the climate change side, we identified polluter pays, or the precautionary principle. Do no harm, again, well established in and having its origins in international environmental law, and a place in the Stockholm and Rio declarations. The duty to cooperate, very contentious in international human rights law, but there nevertheless in Article 2.1 of the Covenant on Economic and Social Rights. And then the notion of equity and common but differentiated responsibilities on the one hand, so in climate change, and then in the human rights law frameworks, the cross-cutting norm of equality, but also norms of differentiation. Then the disconnects, which I've alluded to throughout. I think yesterday I was struck by how a number of presentations corroborated what we had found, which is that the causation issue is probably the greatest one that we face in terms of introducing or encouraging an outlook on climate change that would integrate and take account of human rights. Of course, causation goes to the heart of correlating rights and duties and connecting the actions or omissions of a duty bearer with the realization of the rights of the rights holder. Second, identifying who are the rights holders and duty bearers in the context of climate change is exceedingly difficult. The problem of climate change frameworks being designed to look at aggregate causes and disparate harms, which is really not the way in which human rights legal norms are set up. Then the simple fact that human rights treaties were not designed to tackle climate change or even its social and human impacts, and that reminds me of the point made about the Alien Tort Claims Act yesterday that Michael elaborated. That these frameworks also have very different objectives. I mean, deliberately so, according to one of my colleagues with whom I argue all the time about this, that, you know, we can't assume that this is by accident that these frameworks have been established and persist in separate and parallel tracks, and that institutionally there's very little to connect. We were looking at this in a workshop following the first draft of the study, as to how and whether there were entry points in terms of the UNFCCC process in the run-up to Copenhagen. We found that there were very, very few, and indeed the outcome in Copenhagen, I think, evidences that further. Also at a perhaps more theoretic level, that climate change law may be more forward-looking and designed to consider and tackle harms that are, of course, they're happening now, but also that will happen in the future, where the human rights law framework is more retrospective in outlook. And then an important fact that a framework like the UNFCCC is horizontal in some sense, that it's concluded between sovereign states, where the emphasis of a human rights treaty is between the state and its citizens, and that presents another level of disconnect in terms of the architecture, the legal architecture that governs each sphere. And that finally, the frameworks governing climate change are about global burden sharing and cooperation for collective action, where, for better or worse, most of the, at least classical, human rights treaties are more oriented towards individual complaints and redress. So my final slide is a mix of examples of ways in which we can try to take some of this thinking, not become despondent, or what was it the man Les this morning was full of despair. Let's not be full of despair. I was thinking about Professor Oposa and thinking about the different levels in which these insights may be relevant. So yes, legal remedies perhaps more likely to have uptake on the procedural level than the substantive, in terms of what's come out of the jurisprudence of the various regional commissions in particular. But legal remedies may not be our most promising avenue in the short to medium term. So political pressure is another. Again, for all that it's attacked, human rights discourse still carries a lot of weight politically, still makes people pay attention, even if it doesn't yield the sort of action, or even if it's not implemented in the ways that we would hope. So it's also an advocacy tool. But then some ideas for policy. Yes, it helps us to focus on adaptation, but it also demands that, I mean, if you were to take human rights law seriously in the context of climate change and policy options, you would inculcate a principle of do no harm, which I think would already be, it would be minimal and modest, but it would be an advance. It would require that one would use human rights law as a minimum baseline under which actions of any sort or omissions be judged and not go beneath. And then finally, an idea that we could be more creative about the ways in which human rights impact assessments are used. First, more work is needed, I think, in this area, but also how these tools could be used and mobilized in the context of climate change. I'm thinking even of the ways in which we could expand environmental impact assessments to more explicitly and effectively address human rights issues. And that's it. Thank you very much.
Thank you very much, and now I'm happy to call upon Professor Katrina Wyman of New York University Law School.
First, thank you very much for including me in the conference. I've certainly learned a great deal over the past day and a half and look forward to learning more. So my presentation today kind of picks up in a way with the final remarks of Michelle on kind of the potential to use regional or bilateral approaches to address some of the issues we've been discussing. So my focus is existing immigration laws in destination countries and the potential to use them in the event that large-scale migration becomes necessary from small island states. So I think there's a kind of conventional wisdom out there that if small island states need to relocate large numbers or entirely, their entire populations, that existing domestic law in countries around the world and international law provides really no basis for assisting in this possible migration that, if it needs to occur. And what I'm trying to argue in this presentation is that, well, we should take maybe a second look at immigration laws in countries around the world, that there might actually be something there that could be built upon, and that we may not need a new treaty, as a number of people are suggesting, to deal with the topic of climate change migration, at least as it concerns small island states. So basically the starting point for my argument is that there actually, if you take a close look, there actually is migration already occurring from some of the island states that are commonly discussed as most threatened by, or existentially threatened by climate change. And then I go on to talk about how we might improve existing immigration laws in destination countries to facilitate additional migration from small island states if it becomes necessary. In the end, though, I say, well, I kind of hedge my bets and say, well, we might not want to put all our apples in that one basket of improving immigration laws in destination countries, and it would be useful also to pursue a strategy of advocating for a new international protection agreement, at least put some effort into that basket. Okay. So let me start today. First of all, I'm going to basically do three things. Start with kind of an analysis of existing outmigration from and the extent to which it's occurring and where it's occurring to from the four small island nations that are commonly discussed as existentially threatened by climate change: Kiribati, the Maldives, the Marshall Islands, and Tuvalu. I'm not saying that these nations are the most threatened, but these are the ones that come up a lot in discussion. Then I'm going to develop and apply a framework for evaluating the existing immigration laws through which people are migrating from 3 of these 4 states. And then I have some recommendations. Okay, so existing outmigration. So from these four small island states widely discussed as existentially threatened, if you look closely, you see that 3 of these 4 small island states are already experiencing noticeable external migration. And this migration is probably not due to climate change. It's probably due to a search for economic and other opportunities abroad. So the 3 states that are experiencing noticeable degrees of outmigration already are the Marshall Islands, Tuvalu, and Kiribati. And that outmigration from these 3 island states is occurring basically in a relatively orderly way to 2 developed countries, the United States and New Zealand, to a lesser extent Australia, that probably in combination could afford to absorb the population of these 3 island states if it became necessary because of the impacts of climate change. The Maldives is the exception. In this case, it is not experiencing large-scale external migration, and there's no easily identifiable destination country for the Maldives. As we heard earlier this morning, the Maldives is perhaps, as somebody mentioned earlier, now middle-income country. So it is probably the wealthiest of these 4 island nations, and that may explain in part why it's not experiencing this degree of the same degree of outmigration. So here are a few background facts here. What I've done here is list the 4 small island nations that I've kind of looked at. Their population levels as of 2009, according to World Bank report. Their net migration rate, which is basically a measure of the number of persons entering and compared with the number leaving per 1,000 people. If it's negative, that means the country is losing population. And then I've identified the leading destination country for the citizens who are leaving. Now, what you see here is that according to the CIA World Factbook, which is my source for net migration rates, the Maldives is losing population, but I don't believe this. And I've actually written to the Department of National Planning in the Maldives, and they don't believe this either, so the CIA has gotten it wrong. Probably not for the first time. Okay. And then here you see sort of what are the leading destination countries, and to what extent are there diasporas already in those leading destination countries. So you see the Marshall Islands, the leading destination country is the U.S. There's very poor data on the number of Marshallese living in the U.S. The one source of data is the U.S. Census from 2000, which counted about 6,500, which would be, even if, which many people suspect is an undercount even as of 2000. But that is still a fairly sizable diaspora, accounting for or measuring 10% of the population of the Marshall Islands. Tuvalu has a diaspora in New Zealand, as probably the largest destination country for people from Tuvalu. And the diaspora living in New Zealand, if you count very broadly and include Tuvalus born in New Zealand, probably amounts to 27% of the population of Tuvalu. So you see that there already are, from this chart, you see there already is outmigration, and that there are a number of destination countries that are identifiable. Somebody asked this morning, well, where might people go? Well, from the small island states, here you can get a sense of where people are going, and the kind of premise of my argument is, well, we might want to expand on this existing outmigration to deal with any large-scale migration that becomes necessary. Okay, so the next thing I want to do this morning is briefly talk about the mechanisms, the legal mechanisms through which people currently are migrating from the 3 states that are experiencing noticeable outmigration, and evaluate the extent to which those legal mechanisms, which are provisions in the domestic immigration laws and policies of the countries where they're going, evaluate to what extent do these provisions, would they be able to accommodate large-scale migration if it was necessary because of climate change. So one thing you should realize is that these provisions through which people are migrating are not provisions that enable people to come to the U.S. or to New Zealand on the basis of being suffering environmental harms in their home countries. They're coming under provisions that have no relationship to environmental or harms that people may be suffering in their home country. Okay? I'll explain the provisions a little bit as I go through the evaluation. So I've kind of developed this very admittedly crude evaluation framework for measuring the extent to which existing immigration law in destination countries where people are currently going could be used to deal with climate change migration. So the framework looks at four things. To what extent does the existing legal mechanism, does it provide for the admittance of people from threatened island nations? The more threatened island nations for whose citizens you admit, the more points your mechanism gets. Okay, does this mechanism enable permanent migration, or is it just a temporary migration mechanism? Okay, the idea here is, well, if we have climate change that leads to small island nations being uninhabitable, well, people are going to need to relocate permanently, not just temporarily. Is the migration mechanism open to only people with skills that the destination country is seeking, or does it provide for the admittance of people lacking skills, not just doctors? In other words, we're not just targeting the admission of doctors and lawyers and nurses. Are we going to let in people who don't have skills that we in the destination countries want? And something that would be good to look at, but which I don't do in this current framework, is to what extent does the migration mechanism enable people who are not in the workforce, like children or the elderly, to be admitted? Okay, and so I give you different points depending on how open your migration scheme is. You get more points for admitting unskilled people, because the reality is that a lot of people in small island states would not be able to be admitted under as skilled migrants. They would be persons lacking the necessary skills to be considered skilled. Then the fourth thing I look at in the framework is there a tight cap on the number of persons admitted under this migration mechanism? The idea here being, well, if we need large-scale migration, we obviously want either an uncapped migration scheme, or we want a very generous cap. Okay, so there could be other criteria for evaluating existing migration mechanisms too, which I'm not considering in this framework, but as I said, this is a crude framework in a number of ways. But in the future, we might want to look at, well, to what extent are existing mechanisms providing funding to assist with relocation? To what extent do people who migrate benefit from health and other social benefits when they arrive? These are all things that are important to facilitating migration. Okay, so I identify 6 mechanisms through which people are currently migrating from Kiribati, Tuvalu, and the Marshall Islands to the destination countries mentioned earlier, principally the US and New Zealand. And I score them according to this framework. In the interest of time, I'm not going to go through all the details, but here you see on this slide what I consider to be the most promising mechanisms for dealing with climate change migration if it becomes necessary on a large scale from small island disappearing states. Okay? And I don't suggest, though, as you'll see in a minute, that these mechanisms are perfect. I'm just saying they're the most promising of the 6 out there. So the first, the top 2 that are tied for first place here are the provisions through which many Marshallese are migrating to the U.S., in the provisions that are included in the Compact of Free Association between the Marshall Islands and the United States. These provisions allow an unlimited number of Marshallese to come to the U.S. for an unlimited period of time. They do not provide a path to citizenship, a special path to citizenship for citizens of the Marshall Islands who come to the U.S., but their children born in the U.S. would become citizens. But there is still a gap here that the migrants themselves do not acquire any special path to U.S. citizenship, and it is not it is not easy to become a U.S. citizen through the normal channels. I can personally attest to this, being a Canadian myself and not yet a U.S. citizen. Then the second most promising of the vehicles, the existing migration mechanisms, is New Zealand's Pacific Access category, which basically New Zealand has a sort of quotas under which up to 75 citizens of Kiribati and Tuvalu are allowed to gain admittance to New Zealand This does set them on a path that could eventually lead to New Zealand citizenship. You don't have to have particular skills. It's not a program aimed at admitting only doctors and nurses, but you do have to have an employment offer and meet certain language proficiency requirements. So I classify this as a program admitting unskilled people, but it's not admitting any unskilled people. Okay? So I also see this as a potentially promising program. There are other programs, too, that I score. The U.S. has a temporary worker program. New Zealand has a temporary worker program. So does Australia now. Australia's is not a very successful one, though, which I can go into in the Q&A if you like. One other program I want to highlight that's quite interesting because it suggests a different strategy is Australia's Kiribati Australia Nursing Initiative, through which Australia is basically funding skills acquisition by a relatively small number of Kiribati citizens, basically is providing scholarships to enable them to qualify as nurses. And people benefiting from this program, which is currently around 80 people, could then choose to become nurses in Kiribati, or they could go to Australia. The idea here, though, is that we're going to fund the upgrading of the skills to enable these people to qualify as skilled migrants. We're not creating a special preferential regime, but we're going to fund skills upgrading. This is an interesting strategy. Clearly, it would be very expensive to pursue this on a large scale, but it is an alternative strategy to simply having a preferential admission scheme like the New Zealand Pacific Access category, and kind of an interesting scheme that developed countries might want to consider. Okay, so I then talk about, I'm slowly running out of time here, quickly running out of time, so I won't go into this in too much depth. But even the most promising of these mechanisms, as I suggested, is not ideal for dealing with large-scale climate change migration. So even if you think, for example, of the current provisions in the Compact of Free Association allowing many Marshallese to migrate to the U.S., it still has gaps. As I mentioned before, migrants themselves do not acquire any special path to citizenship. Okay? The New Zealand Pacific Access category is tightly capped. And also, you don't have to be skilled, but you do need to have an offer of employment and meet these language proficiency requirements. But there are a number of things that could be done to improve these mechanisms. So the compact provisions, for example, could be amended possibly to enable migrants to gain a special path to citizenship, or it's possible that Congress, if there was sufficient political will, could pass kind of ad hoc legislation granting migrants already within the U.S. Permanent resident status, and that could put them on the path to citizenship. That's been done in some cases involving Haitians and Cubans. You've seen ad hoc legislation granting people already here permanent resident alien status that's allowed them to then become citizens. Okay. So there are ways these things could be improved to help us deal with climate change migration if it became necessary on a large scale. So what are the policy recommendations? Well, as I said before, the sort of takeaway that my presentation offers, I think, is that, well, we shouldn't rush to trying to negotiate a new international treaty to deal with climate change migration. We should put some eggs, quite a few eggs, in fact, maybe most of our eggs, in trying to improve immigration laws in likely destination countries. I'm not a political naive here. I know this is not going to be easy. But let me start by outlining why I think that we should maybe pursue this path a little bit. First of all, this path has a number of advantages for small island nations. Migration, although this is a very controversial point, could have benefits for small island nations. Economically, remittances may assist funding economic development at home. If migration is available to unskilled persons as well as skilled persons, it could help reduce social inequality at home. Migration also, if migration occurs gradually, migrants through remittances may help fund people to remain in the island nations and perhaps secure that kind of anchor population or nucleus population that people talked about yesterday is vital to maintaining statehood. Okay? Creating diasporas through gradual migration could facilitate later migration if on a large scale if it becomes necessary. There's a lot of research indicating that diaspora communities do help people to settle and integrate later on. Of course, we not only need to make arguments, as somebody said yesterday, to appeal to small island nations, but also to the destination countries. So I think it's, in spite of the tremendous fears about allowing greater migration or immigration in developed countries, and more broadly in destination countries, I think it's worth underscoring that there could be some benefits here to the destination countries of allowing gradually increased migration from small island states. One is that the destination countries could yield some economic benefits. Certainly, many developed nations face demographic pressures, i.e. the aging of their populations, that will require them to probably admit more migrants to meet labor shortages. So there is a kind of argument that, you know, we don't hear maybe so much in the U.S., but certainly you do hear in other countries where these demographic pressures may be more acute for additional migration, additional immigration. Then there's some other potential positives here for destination countries. Allowing gradual migration may reduce the risk of a sudden mass influx. Arguably, it could respond to some of the ethical obligations that developed countries and other destination countries may have for the harm inflicted by their greenhouse gas emissions. Again, here I'm not saying that allowing more immigration is really just a way, should be seen as the most ethically defensible way of meeting those obligations, but it could be seen as part of a response that meets those ethical obligations. Anyway, there's I could go into this more, but I am running out of time. And there's one other point that I want to address is, well, what are some disadvantages of this option, and how could these disadvantages be addressed? Okay, so one of the disadvantages for this option is that for small island states, allowing gradual migration could undermine the ability to sustain the collectivity, to sustain the state, or to sustain viable economies on the state, in the state. Okay. I think it's worth recognizing that, you know, there could be a division of interest here. Citizens of small island states and other states where migration might be necessary might be more inclined to favor migration than governments of those states. Because for the governments, the loss of population could undermine the claim of statehood. Of course, the citizens, too, may not want to undermine the claim of statehood. So there could be less division than I suggested initially, but there still could be a division here. So how could we address this potential concern that more immigration could lead to a loss of collectivity and economic viability? Well, we can pursue other strategies, such as those mentioned yesterday for preserving statehood. Okay? I guess one point that I would just make in closing is that regardless of what strategy you take, whether it's trying to change immigration laws in destination countries to facilitate additional migration, or the international treaty option, which I know the next panel will be discussing, you are going to need to engage with immigration politics in the destination countries. So you may see this strategy is politically difficult, but the international treaty strategy is also difficult, because to successfully implement or even have adopted any treaty, you will need to convince the same populations in destination countries that admitting more people is a viable strategy.
Thank you very much. And our final speaker of this panel is Alona Millar of the law firm of Baker & McKenzie.
Okay. Thank you, Michael, and it's a pleasure to be here in New York for this conference. This morning and yesterday we have heard that climate-induced loss and damage is going to have profound implications on human settlements, on the protection of affected persons' human rights, on ecosystems, and on the support mechanisms that, our oceans and our fisheries. Matched with that, on today's panel, we've heard from Michelle and Katrina and Siobhan that the existing instruments that we have in respect of human rights instruments, migration instruments, and refugee instruments have not been developed with climate change in mind. So whilst there are existing frameworks, they don't specifically address the climate change problem. So what we have is a situation where there's no coordinated legal or administrative framework that will manage climate-related risks and protect human lives, human property, and from the impacts of climate change, or that will really work to compensate those who have been affected by climate change impacts from that loss and damage. So over time, we've seen through the UNFCCC process a push to try and introduce a concept called a loss and damage mechanism. And this is really aimed to try and address these questions of how to manage risk and how to compensate those affected by climate change impacts. That's what I'm going to be discussing today, and I think it links in with some of the issues that were raised by the questions to the first panel about where is the funding going to come from. Where are we going to find the resources, the technical solutions, the capacity building solutions to address the unfortunate but perhaps inevitable situation if people have to address natural disasters, but also addressing slow onset events and the potential for relocation. I'd like to stress that what we're talking about here with a loss and damage mechanism is not an alternative solution. It's not a different approach. It's something that's very much complementary to the existing discourse around this area related to human rights, migration, and those strategies. But I think it is important in the sense that it links in with this particular aspect around financing and planning. So what am I going to talk about this morning? Firstly, just briefly outlining what a loss and damage mechanism involves and why it's important. I'll talk briefly about the legal basis for such a mechanism, look at how this is developed in the context of the UNFCCC debate and the possible content of a mechanism, and then look specifically at the question around risk transfer through insurance and funding and compensation and where that may come from. So to begin with, what are we talking about with the loss and damage mechanism? And I think the way I conceive a loss and damage mechanism is that we're really looking at a process which involves institutional frameworks and also funding mechanisms to respond to climate change related risks that cause loss to property and livelihood, in particular those impacts that are the result of natural disasters and slow onset events. And that mechanism has three main components. The first is a risk management and risk reduction component, and that component is focused on those aspects of looking at adaptation to climate change, developing planning frameworks and adaptation strategies. Then the next component is a risk sharing and risk transfer mechanism, and that is looking at how, when faced by these risks, we can then look at ways of potentially sharing the risk amongst the international community, or potentially transferring those risks through the use of sort of innovative insurance and financial products, which, whilst this is in some way detached from the immediate discussion around impacts on the ground, at a practical level, having those financial mechanisms is, in my view, an important way of being able to respond to both natural disasters and potentially slow onset events. But with slow onset events, I think there is this other sort of discussion around those sort of impacts that are difficult to or impossible to adapt to, and that leads us to the third component of the mechanism, which is looking at the rehabilitation measures, and those rehabilitation measures may include relocation, as we've been discussing, and or compensation to address the losses that's been suffered. So each of these components builds upon the existing framework in the UNFCCC, and I'll talk a little bit more about the specific provisions in a minute. But I think it's important when looking at a loss and damage mechanism, in particular in the context of a legal discussion like the one we're having at this conference, is that I think it's important that a loss and damage mechanism is enshrined through obligations in a legal treaty instrument. So in this context, we're looking at it through a post-2012 agreement that may be amendments to the Kyoto Protocol or a successor agreement. And in that respect, whilst there are existing obligations around that are within the 92 Convention, by having a specific reference to loss and damage, I think it grounds those obligations and then leads to the question of how can you enforce those rights under the Convention through the sort of usual channels of international law. I think the other thing that's important about a loss and damage mechanism is that it has the potential to engage not only with the private sector through public funding, through bilateral and multilateral funds, but also to leverage the private sector. That's, in my view, a very, very significant aspect, because when you look at the scale of funds that will be required to address these problems, the existing funds just aren't sufficient. And even though we're talking about $100 billion per year with the Green Climate Fund, that's envisaged to be a mix of public and private funds. So I think by looking at concrete examples specifically around insurance, but maybe also a compensation fund, then that is one way to really scale up that finance to the amounts of money that we really are potentially looking at to cover the costs associated with adaptation and loss and damage. So why is a mechanism necessary? I really don't need to dwell on this. I think yesterday we saw very clearly that the scientific evidence of climate change impacts is extremely well documented, and we know what we're up against in terms of, in the context of sea level rise, up to 1 to 2 metres of impacts. But I mean, also I think the reason that this is being pressed by groups like the Alliance of Small Island States and the Least Developed Country groups through the UNFCCC process is that these are the groups that are disproportionately affected by climate change. They're the countries that are the most sensitive to climate change, and they're also the countries that have the least adaptive capacity to deal with these impacts. And so in that respect, what you see is a lack of institutional, economic and financial abilities to really be able to cope with the adverse effects of climate change. And in many of the countries that we're talking about, the prevalence of existing risk transfer and risk sharing mechanisms is virtually non-existent. So there's very limited recourse to things like insurance at the moment. So by creating an international framework that will support that, I think a loss and damage mechanism is very important to link through to assist those who are particularly vulnerable to climate change. So moving on to the legal basis of the mechanism. Yesterday, Jake Worksman sort of spoke quite extensively about the no harm principle and the fact that states have a responsibility not to cause damage to the environment of other states or to areas beyond their national jurisdiction. But also the corollary of that is the duty to redress the damage if the transboundary harm does occur, so this concept of restitution and compensation. And as we heard yesterday, there are a number of difficulties in terms of enforcing these obligations under international law. And I sort of certainly agree with all of the comments that were made there. But it's interesting to look at what people have, looked to do in the context of the no harm principle in this space of a loss and damage mechanism and compensation. And Rhoda Verheyen and Peter Roderick have looked at this specifically on behalf of the NGO Oxfam. And the way that they sort of look at a loss and damage mechanism in the context of the no harm principle is that states have failed to prevent or minimise the impacts of climate change damage. And that failure, if that failure is able to be recognised by the international community, it would constitute an international wrongful act. If you're able to establish that an international wrongful act has occurred, then the consequence is that potentially the state that has committed that wrongful act should have to prevent further damage. And one example of the way in which that restitution could take place is the most obvious example is in terms of the level of ambition around mitigation, but linked back to this concept of a loss and damage mechanism, Peter and Rhoda look at the concept of looking at financial compensation being one of the ways in which this is responded to. As I mentioned before, using the no harm principle is very difficult. There are examples of compensation funds that have been established where you have a clear link to an international wrongful act, such as in Iraq. But I think it's actually better to, or in my view, more appropriate to look closer to home to find the legal basis for a loss and damage mechanism. And that brings us back to the UNFCCC's existing approach through Articles 4.3, 4.4 and 4.5, which specifically place an obligation on developed country parties to provide financial resources to developing countries to facilitate adaptation. In particular, Article 4.8, which sort of elaborates on this, looks at the types of measures that may be used in terms of developed country parties, giving consideration to actions relating to funding, insurance and technology transfer to meet the specific needs and concerns of developing country parties. There's an equivalent obligation in the Kyoto Protocol, and so from the very beginning we have had this link in the Convention and the Protocol to the potential to use mechanisms such as insurance to help developing countries address their adaptation needs. There are also sort of extensive programs within the UNFCCC framework with respect to adaptation, the Programme of Works, the NAPA program, which was mentioned this morning, and also the Hyogo framework, which addresses specifically disaster and risk management issues. So there's a basis for discussing loss and damage, but it has been incredibly controversial. IACHR raised this back in 1991 when the preparatory meetings for the convention were taking place, and they had a proposal on the table which was effectively to establish an international insurance pool to compensate small island developing states and low-lying developing nations for loss and damage resulting from sea level rise. So this proposal had a very interesting mechanism to assess the contributions that developed countries would pay to this insurance pool, and that was based on a formula that involved the GDP of the developed countries and their contribution to greenhouse gas emissions. So it was really looking at historic responsibility and also the ability to pay. So using a fund mechanism to effectively create a pool from which developing countries could draw funds to assist with their adaptation and their response to loss and damage suffered as a result of climate change. Whilst that funding mechanism never made it into the convention, there was that reference that I mentioned before in Article 4.8 to insurance. Over time, IACHR has continued to sort of raise the potential for including a loss and damage mechanism in the convention framework, and as the post-2012 discussions have taken place, this has gained additional momentum. In the lead up to Bali, IACHR has put a similar proposal to the insurance pool back on the table at the Vienna meetings, and then what we saw in 2000 at the Bali COP in 2007 was a reference in the in Decision 1 CP13, which in the context of the adaptation building block specifically referred to consideration of a loss and damage mechanism. IACHR then really elaborated on that proposal through submissions that were made during the course of, actually it was 2008 and again in 2009, and they've really sort of pushed for this multi-window mechanism within the convention that would have the three components, effectively the ones that I mentioned at the outset, but an insurance component that would assist particularly vulnerable countries manage the financial risk from extreme weather events, a rehabilitative or a compensatory component which would address the unavoided and unavoidable impacts, and then a risk management component which would assist in risk management planning and risk assessment planning. So that mechanism was put on the table along with a proposal to establish a convention adaptation fund, and that convention adaptation fund would effectively use a similar metric to the one mentioned in 91 in terms of trying to have a basis upon which you assess the contributions that should be made by developed country parties. So what's happened since then? At Copenhagen, other things took precedence, but what we saw with the Cancun agreements was firstly a specific reference to the need to address these issues of risk assessment, risk management, and risk transfer. Also, as was mentioned earlier, there was the first specific reference to addressing the issues around relocation and forced migration in Decision 1 CP16. But in the context of a loss and damage mechanism, what the COPPers asked parties to do is to develop a work program which will be governed by the subsidiary body for implementation, which in itself is significant because that is the body of the arm of the convention that actually focuses on sort of more direct action than substa. But the types of things that countries have been responding to include looking at climate risk insurance facilities, looking at options for risk management and reduction, and risk sharing and risk transfer mechanisms, looking at approaches to address rehabilitation and ways to engage stakeholders. So there was a call for submissions that parties responded to. We had 22 submissions from about 98 countries that mainly focused on how to develop this work program. But what we're seeing is, I guess a general consensus about the things that need to be firstly carried out in order to understand what would be included in a mechanism, but also what the components of a mechanism may be. I think the most important thing is that a mechanism needs to be country-driven, and it will be different for different states. And again, that drills down to both to the local level as well. But in terms of what is needed, there's an information gap, and on this slide, I've mentioned quite a lot of sort of areas where there are needs to look at further data around risk exposure and modelling and things like that. There also needs to be a framework that looks at how to reduce the exposure to risks, and that looks at how to enhance existing and possibly new prevention and reduction measures, more so in the context of disaster preparedness. And then for those risks that can't be prevented or reduced, looking at these risk sharing, risk transfer and rehabilitation and compensation mechanisms. But most importantly is who covers the cost, because all of these steps involve some form of, someone needs to underwrite the costs. So in that respect, insurance, I won't go into insurance in a lot of detail, but it is very much the mechanism that has been contemplated most widely in the context of a loss and damage mechanism. I mean, these are just some photos from Hurricane Katrina, but if you look at as I mentioned before, developing countries at the moment really haven't used insurance to the extent that they possibly could for a number of reasons, which I will mention. The types of insurance that have been contemplated include the traditional insurance mechanisms that people would be familiar with, which is essentially guaranteeing financial protection against stipulated losses in return for paying a premium. The question is where does the funding come to cover the cost of that premium? You also see some really innovative products being developed in terms of microinsurance and insurance-linked securities. I can talk more about how they operate in questions if people are interested. But we have seen examples in Mexico, in the Caribbean, in Turkey, using these types of products to deal with these types of issues. Given the time, I won't spend too much sort of dwell on the problems, but I mean, I think importantly, the premiums are an issue. There are moral hazard issues in terms of people not having an incentive to mitigate loss, and there are also difficulties in terms of whether or not insurance is in fact appropriate for slow onset events, which I personally think it's not going to work in that situation. A number of non-insurance financing mechanisms are also available, and these will be sort of dealt with in a lot more detail in my paper. And some of them have already been mentioned today in terms of things like remittances and how they can operate and assist in funding a loss and damage mechanism. But importantly, it's what's happening at a big picture international level around funding. And as I mentioned before, the existing funding under the UNFCCC framework through bilateral partnerships, development aid, are just not effective. So essentially, what's on the table is the Convention Adaptation Fund proposal, which could be a standalone fund, or it could be a window in the Green Climate Fund, which is proposed under the UNFCCC. The question on how to structure the responsibility to contribute to that fund is something that will need to be discussed in more detail, but I think the proposal that AOSIS has put is trying to balance and use an equitable sharing of responsibility amongst developed countries to contribute to a fund. And in the paper I go into, again, more detail about what would be required in terms of an administrative framework to address the operation of that fund, how it could be accessed, what it would fund, what types of activities would be eligible for funding, and what the baseline thresholds would be to decide whether or not an event has happened that would require funding. So associated with that is in-kind support, technical assistance, cooperative policies, which links back very much to the way in which countries address their existing migration policies. And then I think just in terms of my sort of concluding remarks, I think that this has the potential to assist with risk preparedness and risk management, both for sort of natural disasters and slow onset events. It has the potential to work to facilitate risk transfer for natural disasters, and also to potentially compensate for unavoidable loss. Importantly, it's the link to finance. And the final point, in terms of how this relates to the question of mitigation, is I do think that discussing compensation is an incredibly controversial issue, and if you start discussing compensation and the potential that developed countries are liable, it may be a leverage tool in the concept, the content of the debate around mitigation and the level of ambition for the target. So when thinking about, I guess, a negotiation strategy, this may be one of the things that, in small part, could leverage the relationship with developed country parties on the mitigation side. And that's it from me. Thank you.
Thank you very much. We have only about 10 minutes before lunch, but we will have more time in the afternoon for discussion of the many important issues. But let me now open it up for Caleb.
Thank you. And I wanted to ask a question of the most recent panelist, Ms. Millar. And first of all, thank you for your presentation. I have the privilege of working with Ambassador Muller and Mr. Kamanaga and the UNFCCC negotiations, and as much as I was enjoying a short vacation from all of the acronyms that accompany them, I think that you've raised some important issues because there are some broader interlinkages, particularly around this issue of slow onset effects, including sea level rise. And I think, as you noted, the concept of insurance is in the convention, and we've kind of had a 20-year debate about this, somewhat circular, and I think that this moved forward most recently last December in Cancun, where we now have this work plan where we're trying to get much more specific, really taking this apart and trying to look at many different proposals and ideas. And, this issue about compensation, on one hand, where there is a wrong, it seems that there is a remedy. But it becomes a little more complex when we think about slow onset effects, and this whole notion of sort of a global compensation mechanism is circular. We can appreciate the principles, but it's politically complex. It might lead to something that may be so large that it might not necessarily be designed to respond to those who might have first proposed it. In some sense, I mean, you might, is this something that's going to have, thousands of staff people in an international secretariat, and that's hard for a small government to keep up with. There are some open questions about financial compensation in putting a price tag on things and replacement values. And the Marshall Islands actually has prior experience in having been through some of that valuation process. So as we're trying to just think broadly and creatively at this stage, specifically around this issue of sea level rise, of slow onset effects, we're trying to look for prior examples, and one of the ones that has come up has been trust funds, which in the Pacific have been used by a number of countries, including the Marshall Islands, and generally have a good track record in these submissions from other countries. Mexico referenced this in their submission. So I'm guessing or rather my question would be, if you came across any prior models that might have some sort of a track record in addressing long-term risks, particularly within the Pacific region. I know we have, climate insurance within other regions, or not climate insurance, but disaster risk insurance on kind of a shared regional model. But we're really trying to think a little more deeply about the slow onset effect, because there are a number of hurdles to get through in that. Thank you.
Okay, thank you for that. And I would say there are quite a number of examples in respect of the immediate natural disaster events. You mentioned the Mexico fund proposal. There's also funds that have been set up in, for example, in Turkey, to a catastrophe fund, which takes revenue, and then in the event that there is an event, it will distribute and pay out. But nothing that I've seen has been put in place for slow onset events at this stage. When IOSIS was developing this proposal in sort of 1991, and again when we looked at it in 2007 and 2008 and developed the multi-window proposal, what we were looking at is, how do you establish a mechanism for a fund to pay out? And the big question is, what is the trigger for that fund, for that payout? In the context of a slow event like sea level rise, the question is, when has that sea level rise taken place to the extent to which you would trigger a payment? And that type of mechanism importantly requires very clear baselines. And one of the things that was lacking in 1991 was a real understanding of from what point are you measuring sea level rise in respect of what fixed point in time do we say sea level has increased by half a metre or a metre, therefore we can measure that and we can now sort of pay out from the fund. So there, as far as I'm aware, no examples of long-term insurance mechanisms. More so in respect of the more immediate mechanisms. Drought is an interesting one. There are certainly insurance products that deal with the impacts of drought, but again, that really sort of sits in the middle of a sea level rise, as compared to a hurricane event.
Greg?
Yes, this is a question mostly, I think, for Michelle and Shaban. You, too, of course, are involved with very large multilateral institutions that are often on the front lines in implementing human rights protections. And I wanted to jump a little bit on this question between the relationship between what language exists, what protections we see, and how that language can be applied, in fact, in your activities. You mentioned that somewhat. I would be interested to hear, I guess, generally in what language you think would be required, and what sort of what protections are needed for your institutions to effectively help these threatened island nations to implement the human rights protections that would be necessary in resettlement activity. And specifically, I wanted to ask, Michelle, you mentioned the placeholder language, and I think there are a large group of people who are very interested to hear about that process in Cancun, and we're excited to hear about your and Coco Warner's and several other people's efforts to get that language there. And I guess I'd be interested to hear what the next step is.
Which of you would like to start?
Thanks a lot. I should just clarify that the World Bank doesn't have a mandate in protecting human rights, and indeed, as David, who has been in these trenches for many, many years, probably happening not any longer, but we struggle with this because of the political prohibitions of that are contained in our constituent instrument, the Articles of Agreement. So we very definitely have no comparative advantage when it comes to human rights protection per se, much less enforcement or monitoring. So just that as a point of clarification. That said, the work of the bank, including in relation to climate change, of course, relates substantively and in fact with a lot of areas of human rights, or areas that are governed also by human rights treaties, and our members are also the same countries that are states parties to these core international human rights treaties. So that is relevant. But from an institutional vantage point, and I speak completely in my personal capacity, part of the challenge has been encouraging a more systematic approach to human rights obligations, greater clarity around the points of connection with development, and including where the bank is active in climate change, and I think tackling issues at a macro legal and policy level, which I tried to outline very briefly in my presentation. So far as language that's effective, I think it's a key point, actually. It's not semantic at all. And language that would be persuasive in this context, in the World Bank setting, would be language that is grounded in evidence-based approaches. So it's not necessarily the purview or the area where lawyers contribute the very most because of this type of approaches and methodologies that we would use. But I do think that work on establishing the evidence base, working with partners that are in the process of establishing that evidence base is really critical. And then the how question. How would you do this? Identify entry points in processes and in instruments, and also show practically how it would be done. So often the people making decisions in our institution are very practical people and want to know how would you do it. And when we've done even just limited research to understand the state of the art on human rights impact assessment is actually much more limited than we would have expected in terms of application. Yes, in theory, but in terms of application. So I hope that answers some of your.
Thanks very much, Greg, for the follow-up question. First, you're right on the terminology. Let me refer in more detail to what I mentioned very briefly. It's paragraph 4F of COP15 that deals with adaptation and specifically has language in F that says looking to promote measures to enhance understanding, coordination, and cooperation related to national, regional, and international climate change-induced displacement, migration, and planned relocation where appropriate. As I mentioned, that's a placeholder, but it's an important one. That language is okay in terms of terminology as a basis for moving forward. I did spend a fair amount of time in my presentation talking about why refugee doesn't work, and I think the language as adopted reflects that. So it reflects that we're looking at multiple scenarios, none of which fit a classic refugee definition, but which could involve climate change-induced displacement, migration, and planned relocation. Now, this moving forward, and there was a very long history in getting even that little tiny placeholder in there. It took about 4 or 5 years of negotiation just to get that placeholder, and it nearly got dropped out at the very end. And you'll see in our written submission, all the details of how that happened. And it was important that the word refugee not be used in order to create it. It was important that a measure was framed as enhancing understanding, coordination, and cooperation, rather than imposing a particular legal obligation. All of those things went into the sort of the political palatability of putting that in. So for some, it's obviously more watered down than they had hoped, but at least it's a lot better than what was risked in the final stages of the negotiations. Moving forward, I think the key things from our perspective, and this is something that Koki and we share, is that one possibility, and it'll certainly come up in the next session, is whether or not it makes sense to develop some guiding principles around climate-induced displacement, so for external displacement, in a sense mirroring what exists with respect to the guiding principles on internal displacement. And I think that's an interesting discussion to be had, and I would like very much to see that had. Second is very much to look at increasing the range of adaptation measures for vulnerable populations. And this goes very much to what Katrina said about opening up more legal migration channels for the reasons, precisely for the reasons that she articulated. I mean, that where you have legal labor migration, it not only can reduce pressures on vulnerable areas, but also generate remittances that can be potentially fed back into adaptation strategies. I'm aware of some very interesting bilateral programs going on right now, small scale, but for example, between Colombia and Spain, where facilitated labor migration from areas of high environmental degradation, specifically to reduce pressure, and with those funds, which remittances obviously are private funds, but they are supplemented by public funds that are invested in creating new livelihood alternatives in those same communities. And green technology alternatives coupled with them. There's some really very creative things that are starting to happen. Third would be to look at, obviously, reducing the incidence of forced displacement and really mapping better hotspots where, and it's possible to do that, and of course this small island discourse very much focuses on that, but it's very possible to look at, particularly on the slow onset, where the greatest pressures are, and therefore where targeted interventions can potentially reduce pressure and create alternatives. Fourth is coming back to something that somebody raised before, and that's the mainstreaming of migration and displacement related factors into NAPAs and to other adaptation frameworks. We still have too much of a disconnect between the climate change community and the migration community, and we really need to link those up in a more fundamental way, and the NAPAs are really the place to do that. There are some pilot testings to do that going on now. I'd be happy to share that with anybody who's interested otherwise. And then final point is, from the humanitarian community, we really need to move more from a response mode to a proactive mode. I mean, so much of what takes place in the humanitarian community is after the fact, and only after there's been terrible loss of life and damage. And particularly with slow onset, we can really start moving more to preparation and reducing vulnerability, and that makes an enormous sense for saving lives and reducing costs. So we must move to that now. Thank you.
Lunch is upstairs on the next level up. You can take the elevator up to 3 or take the stairs up one level that are near the front door. We will resume at 2:15. If you have not yet registered and gotten a name tag, please do so, because you'll need that for the dinner tonight. We'll be back here at 2:15.